Hi, I'm Ieshia Dunmore. I am an associate attorney here at the Cromeans Law Firm. Arbitration is a formal dispute resolution process. It's important to know the ins and outs of arbitration because many times your contracts, whether they be between an owner and a GC or a GC and a subcontractor, many times those contracts include a requirement for arbitration. It's important to read through your contracts to determine whether or not you are subject to an arbitration clause, because in the event that your dispute is subject to an arbitration clause, you have effectively waived your right to a judge and a jury. Now, although that may sound scary, there are some benefits to arbitrating. Sometimes arbitration can be less costly than litigation, and it can also be a little quicker than litigation. Our courts sometimes can take anywhere from 2 to 3 years in order to properly resolve a dispute by a judge or a jury. Whereas an arbitration, on the other hand, it's kind of similar to the mediation process where you present your dispute to a third party, but in the arbitration process, that third party has the right to decide your dispute. It is important to be represented by counsel during this process, primarily because you want to make sure that all of your rights are protected, and with arbitration you only get one swing at the bat. Basically what that means is once the arbitrator makes the decision is final and it's not appealable. If you are in a contract that is subject to an arbitration, or you feel like there's a conflict arising under a contract that is subject to arbitration, please feel free to contact our firm here, the Cromeans Law Firm, in order to discuss your matter with one of our attorneys.